So the Supreme Court just issued a new 6-3 decision in a case that is going to have huge implications for the Second Amendment in all these lawsuits going forward. Essentially, the Supreme Court just outlined when they will and will not take emergency review of 2A cases. Now, real quick before we jump into this video, I want to ask you all for a huge favor. Looking at some of my analytics, about 60% of all my viewers are not actually subscribed to the channel. So if you enjoy this type of content, if you want this information to get out to more people, or you just want to support the channel for free, please consider subscribing to the channel. That really does help this information to get pushed to more people. And again, it just signals to the algorithm that you guys appreciate that. But regardless, thank you guys so much for all of your support. As I mentioned in the intro, we received a huge 6-3 decision by the Supreme Court this Monday in a controversial case, and this has huge implications for the 2A cause going forward. This decision by the Supreme Court not only outlines that they are adamantly against universal preliminary injunctions going forward, and also it demonstrates how various justices and what their opinions are on how the Supreme Court will review emergency cases through their emergency docket. This decision will not only impact the type of injunctions we will be able to get in 2A cases going forward, but also it will dictate when the Supreme Court will take cases on an emergency basis going forward. The case and opinion we're going to be breaking down is called Labrador versus Pope. Now, this lawsuit arises out of a controversial law that was passed in the state of Idaho. In 2023, Idaho adopted the Vulnerable Child Protection Act. The law sought to regulate certain practices essentially about altering, gender and all that. The law's provisions were scheduled to take effect on January 1st, 2024. Now, before that could happen, 2 children and their parents sued the state of Idaho, the Idaho Attorney General, and local prosecutors in a federal district court. Shortly after filing the lawsuit, the plaintiffs asked the district court to issue a preliminary injunction. The district court agreed and did issue that injunction, which barred the state of Idaho from enforcing this law that they put in place. But instead of enjoining just the state officials from enforcing that law with respect to the individual plaintiffs and the individual drug treatments that were being sought to be prevented in the state of Idaho, the district court entered a universal injunction. Idaho responded by appealing to the district court's injunction, appealing that preliminary injunction, and that went up to the Ninth Circuit Court of Appeals. Now, what the state of Idaho also argued for was, at the very least, for the universal aspect of that injunction to be removed and for the injunction to only apply to those individual parties that are named in the lawsuit. But again, the Ninth Circuit denied that and kept in place that universal preliminary injunction. That then led the state of Idaho to file an emergency application through the Supreme Court shadow docket up to the United States Supreme Court, seeking, emergency intervention from the Supreme Court. In the emergency application, the state of Idaho did not challenge the preliminary injunction to the extent it applied to the 2 specific named, individuals in the lawsuit, the, kids in that lawsuit or their parents. Instead, it sought for the Supreme Court to overturn the district court's universal application of that preliminary injunction and simply leave in place the more limited aspect of it to those parties and still let the state of Idaho apply the provisions largely to other individuals in the state. And in this order, the Supreme Court ruled in favor of the state of Idaho. In a 6-3 opinion, the Supreme Court found that the district court's universal preliminary injunction was in fact improper. They also found that the lower courts should no longer issue these types of universal preliminary injunctions. And they also outlined what their approach will be going forward when trying to deal with these types of emergency applications that are making their way to them. This decision is highly relevant for multiple Second Amendment cases that have gone to the Supreme Court on emergency applications through the whole shadow docket, but also this decision by the Supreme Court will now set the standard for what type of relief district courts are going to be issuing going forward. In fact, it seems that the universal preliminary injunctions or nationwide injunctions or statewide injunctions could be off the table. This decision was a 6-3 opinion, and the majority of the court was Gorsuch, Thomas, Alito, Roberts, Barrett, and Kavanaugh. Of course, the dissenters were Kagan, Jackson, and then Sotomayor. Now, what is very interesting is kind of the 2 separate camps of concurrences. Justice Gorsuch wrote a concurrence which was joined by Justice Thomas and Justice Alito, and it kind of outlines their perspective. And then you have a different concurrence with a different camp, which was Kavanaugh and Barrett. In the Gorsuch concurrence, he states that early in the litigation below, the district court issued a preliminary injunction. Ordinarily, injunctions like these may go no further than necessary to provide interim relief to the parties. In this case, however, the district court went much further, prohibiting a state from enforcing any aspect of its duly enacted law against anyone. Today, the court stays the district court's injunction to the extent it applies to non-parties, which is to say, to the extent it provides universal relief. That is a welcome development. What the statement means right there is that universal, statewide, and maybe even nationwide preliminary injunction relief is now going to be deemed improper by the Supreme Court. This fact will both benefit and in some ways also hurt the pro-2A side in the movement going forward. District courts are now directed to limit preliminary injunctions and the type of relief that they grant to just the parties involved. Many times in 2A cases, we have been able to essentially get district courts to entirely strike down state bans, in the entire state, magazine bans, rifle bans, carry bans, and we've done that through preliminary injunctions and got that applied statewide. Also in lawsuits against the federal agencies like the ATF, we've been able to get nationwide preliminary injunctions, stopping the enforcement of things like the frames and receivers rule or the pistol brace rule. What the Supreme Court just said in this opinion is that those types of preliminary injunctions may be found improper if the relief goes beyond the named parties. The Supreme Court says that if a district court issues a nationwide or statewide preliminary injunction, that can trigger Supreme Court emergency review for the court to strike that down. Now, some of the Supreme Court believe that this approach will also reduce the number of emergency applications that are being sent to them. That's essentially because if a preliminary injunction is only applied to the individuals, to the named parties, one or two people in a lawsuit, it's much less likely that either side will then complain about the type of relief, say it's overbroad, and then go up to the Supreme Court. So they're trying to do this or limit the relief to also limit the amount of applications or emergency applications that are being sent to them. Justice Kavanaugh and Barrett agree with that approach, but they also believe the case should be actually deemed to be cert-worthy before the Supreme Court grants emergency applications. Justice Barrett says that emergency applications should be taken only if a case is also deemed to be cert-worthy. Justice Kavanaugh agrees, and he states in his concurrence that, I fully agree with Justice Barrett's important insight. Emphasizing cert-worthiness as a threshold consideration helps to prevent parties from using the emergency docket to force the court to give a merits preview in a case that would be unlikely to be taken. However important in the Kavanaugh and Barrett camp's opinion is the fact that even if the relief is limited to just the named parties, there is still the potential for broad relief. So this whole video isn't to be saying that, injunctions going forward are only going to be limited to individual named plaintiffs. Kavanaugh and Barrett and some of the other concurrences are outlining that there are nuanced situations where the type of relief that is granted could still be broader than just the individuals. Kavanaugh points out that there are situations where maybe a state itself might be a plaintiff in a case, or maybe even large organizations. That means that in practice, there still could be statewide preliminary injunctions or multi-state injunctions through organizational plaintiffs. A great example of this would be, the state of Texas being a named plaintiff in a lawsuit, or maybe 2A organizations also being named plaintiffs in challenges like the ATF pistol brace rules. The preliminary injunctions in those cases have been limited in some of those cases to just the 2A org and their memberships, and then it's also been limited to just the specific states. However, there is also the Brito case, which has a nationwide vacatur of the rule where that happened in that case. The Supreme Court, in this opinion, is maybe signaling that maybe those type of nationwide vacatures would be deemed improper and could be struck down, while the organizational injunctions would stand, or the statewide injunctions where the state is a named plaintiff could also stand. Now, the only caveat to this is that Justice Kavanaugh, in his concurrence, acknowledges that when it comes to the APA challenges like against the ATF and their rules, there is statutory language that could result in a nationwide vacatur of a rule that could have a nationwide effect. So what is the big takeaway of what happened in this decision, and how is this going to impact the Second Amendment movement going forward? Well, statewide and nationwide preliminary injunctions are likely going to be off the table except for specific situations. Relief is going to be directed by the Supreme Court to be a little bit more limited to just the parties in the cases. That means that you will probably see more states and more 2A orgs being actually named as parties in lawsuits. Now, on the other hand, this is going to be really positive in some ways and in some aspects, because you have states like Texas that pass very pro-2A laws that are going against what the federal government wants and is trying to cut back at a state level against Second Amendment violations. Now, when the federal government sues these states, they want to get broad-reaching preliminary injunctions which strike down the entire law in the entire state. And what the Supreme Court says is no, if the federal government is going to sue these individuals or try to stop this, it has to apply just to the named parties, but it cannot be statewide. It cannot strike down the entire provisions. I know some 2A orgs are already pulling the decision from the Supreme Court here, and they're trying to use this to reverse statewide or nationwide preliminary injunctions that the government has already received. It will be interesting to see how this rolls out and how it's going to be applied going forward in 2A cases. So as things develop, I will let you guys know. Also, if you like this video and you like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of 2A news. But as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.